Welcome. Good morning. Welcome to Get It Right, Use Official Laws, brought to you by the New Mexico Compilation Commission. I'm Brenda Costello, Executive Director and Chief Financial Officer of the Compilation Commission. What a nice audience this morning. You look great out for your free CLE. We extend our appreciation to the State Bar for assistance, its wonderful staff assistance, and for the use of the auditorium. So thank you, State Bar of New Mexico. Before I introduce the presenters for today's program, let's just take care of a couple housekeeping items. In your packet, you have a survey, and that survey is to provide the Commission with feedback that we'll be using for long-range strategic planning in the coming year to 18 months. So if you would, please fill that out and drop it off at the registration desk in the hall. We really appreciate your comments and your feedback. We have a Q&A session scheduled for the end of the program. So if you would please hold your questions until that time, and we promise to get to as many of them as we possibly can at the end of the program. At this time, I'd like to introduce our distinguished faculty. First, Honorable Supreme Court Justice Edward L. Chavez. Raul Burciaga, Director of Legislative Counsel Service. Joey D. Moya, Clerk of Court and Chief Counsel for the Supreme Court of New Mexico. Carolyn Wolf, Montgomery and Andrews, and former in-house counsel to some of the largest New Mexico state government agencies. And Garrett Don Reagan, all the way from Hobbs, private practitioner, former state senator, and former state bar president. And on keyboard this morning is Brad Terry, the Commission's Education and Awareness Representative. He's supporting us with live demonstrations on various websites and on several products. And I'd also like to take this opportunity to introduce you to someone that most people never see. He's our unsung hero. He's our lawyer editor at the Commission, Mr. Ralph Trujillo. So you'll hear mention of Ralph's work throughout the program with regard to annotations, case history alerts, compiler's notes, new section numbers, and so forth. So that would be Ralph. And now, let's begin our program. Please join me in welcoming our keynote speaker, the Honorable Justice Chavez.
Good morning, everyone. You know, we're expecting like 136 people, so as you come in, please take a seat. This program will go until noon, so find a seat. It won't interfere with the program at all. I was interested. I looked, frankly, for the first time at our program this morning, and I know it's been given to me in the past, but this is really reasonably priced, right? Yeah, this is a great program. I was told we'd get 136 people, and I wondered why, and I thought to myself, surely they want to know what the official laws are, right? And then I look at this 2-hour general credit hours free, and I never like to make those assumptions, but I think that's a safe one. Well, let me tell you, the goal of my presentation today is to talk about the official position of the Supreme Court of New Mexico. And frankly, I think in order to be able to do that, I need to share with you briefly some of the history of the New Mexico Compilation Commission and the compilation of the laws in the state of New Mexico, the Supreme Court's involvement in that regard, so that you will appreciate why it is that we are very proud of this product. I believe that it's the only product out there that keeps you current and that will keep you accurately citing to case law. I want to talk to you about rules of efficiency in our court system and the consequences when the rules of efficiency are not followed. And then I want to demonstrate for you how the system works. How many of you are familiar with NMONESOURCE? Okay, so there's a fair number of you that use it. How many of you use the CD-ROM? Okay, what about online? All right. So that's a good fair number of people. We might be able to have a decent dialogue then about this. And I'll be able to show you how it works for New Mexico cases and how it works for cases outside of the state of New Mexico, the federal courts, and also law review articles. I think if I do my job right, what you will get is an outline for the details of the other speakers who have a lot more expertise in the use of this. I have law clerks. They're a lot better at this than what I am. So I'm taking a risk here coming to talk to you about this. But what's fascinating about the history of New Mexico is it began with the Kearney Code of laws that were published back in 1846. And other than that, truly it's been the legislature that has dominated the direction for compiling all of the laws in the state of New Mexico. And in fact, the New Mexico Supreme Court has been involved since day one. Back in the 1800s, there was sort of a renegade, a Chief Justice, who decided on his own that he really didn't like what the legislature had approved as far as the compilation of the laws back in the late 1800s. So he decided to keep his own compilation of the laws, not anything we recommend our justices do these days. So the courts have always been involved with the compilation of the laws. The Chief Justice has been involved, and as you will see in your materials, if you look at section 12-1-2, you will see the creation of the New Mexico Compilation Commission. It was created back in 1941. It had 3 members: the Chief Justice, who was supposed to serve as the president, the clerk of the court, who was supposed to serve as secretary, and then we had the Attorney General. And it was those 3 individuals who were responsible for putting together the compilation of all of the statutes, the legislation that was passed by the laws. And then in 12-1-3 in your materials, you will see that the Supreme Court then has delegated the responsibility by the legislature to appoint an advisory committee. And we appointed 11 members. Some of them are here. I saw Professor Browdy. That's to recommend to the Compilation Commission, right, what actual laws are to be published and those that are actually adopted by the legislature. But in 1982, that's when it becomes relevant to the courts, because in 1982, the Compilation Commission became statutorily responsible for publishing court opinions in the New Mexico reports. And you probably remember the books. I know the young lawyers, they don't understand books. They really don't understand, they don't understand checking accounts. They do everything online. So the Compilation Commission became responsible for those in 1982. We've led the nation in a lot of respects at the Compilation Commission. In 1987, we became the 2nd state to convert everything to an integrated database, which allowed us to develop the first electronic version of the statutes. And in 1990, we became the 1st state to put all of our laws on a CD-ROM that was known as New Mexico Law on Disk. And then in 2004, the New Mexico Compilation Commission became the official legal publisher for the laws in New Mexico. The important thing about the laws in New Mexico is we also adopted rules with respect to how they were to be cited. And in 2012, under the leadership of then Chief Justice Charles Daniels and Joey Moya, the General Counsel and Court Clerk, we now have authenticated PDFs that are used instead of paper opinions. And the result of that has been that with the website, you will see almost real-time production of Supreme Court opinions and also any amendments to your rules. The website also gives you annotations to your rules, to your jury instructions. We believe that this becomes an important tool for the attorneys in New Mexico, because we have experienced situations where an opinion is issued, it's commented on an existing jury instruction and recommended changes to the jury instruction, actually offered what those changes ought to be in the jury instruction. Now that that opinion is published the day that it is filed on the commission website, it is available to the lawyers who are in trial or have an impending case coming up to look at and be able to research and be able to adjust the case law for the court. What has happened is at times lawyers have not accessed current case law in New Mexico. They've tried their case, they've been told the judge what a particular instruction is. It ends up being wrong, although there was a case already published on that point. It ends up on appeal and it gets reversed. And so as a result, you've missed out on an effective presentation of your case. The official position of the New Mexico Supreme Court is that this is a good product. This is the best way to make sure that the attorneys and the bench are all up to date with respect to the laws in the state of New Mexico, with respect to the rules. And we think it's the really good tool to use to be able to access case law interpreting rules, case law interpreting legislation. And there's also forms that are available that I'm sure some of the other presenters will talk to you about. It's also important, I think, for us to talk about the efficiency rules that we have in New Mexico. I call them efficiency rules. I don't think there's any official title. But if you think about, for example, in district court, Rule 56, the summary judgment motion, that's really an efficiency rule. I think lawyers look at it as a burden, that you're just making us be overly technical with our presentations. You have to identify the material issues of fact that are not in dispute, right? But now we require you to number them. And when you file your response, you have to identify specifically which issues of material fact you believe are in fact disputed. You have to cite to the record. And if you think there are other facts that are relevant to the legal issue at hand, you have to identify those and by number. That's a rule of efficiency. And the reason it is because you identify the issue that is really before the court. You tell the court precisely the facts that are material to the case, and if the other side does not dispute those facts, they're deemed admitted. It makes it easier for the judge to actually see where the fact is. Your obligation is to cite specifically to the record, an affidavit, a deposition testimony, an answer to an interrogatory, whatever you are relying on. That is not only for the benefit of the courts, but it's for the benefit of opposing counsels so that they understand your argument. Now, it might be a lot easier if you're able to just say, in the record is the following evidence, which means that your opponent is going to have to invest a lot of time and resources trying to find out whether or not you have accurately represented the facts in the case. But that's not what our system of justice is designed to be. If you look at rule number 1 in our court rules, it's designed to be a fast, speedy, and inexpensive process. And so these rules, although they might require you to do more than what you would want to do, they really do improve the efficiency of the court. And that becomes very important. In our briefs, if you look at Rule 12.213, filing briefs in our New Mexico courts, you're supposed to cite accurately to the record. And we now have a neutral citation system that's in use. You use the date, the year that the Supreme Court opinion was published, and you would put NMSC, and then the sequential number for it. Same for the Court of Appeals. The only difference is you use NMCA. The other important thing that New Mexico has done, unlike most other states, is we have a paragraph number requirement. And that makes a big difference in terms of efficiency. And whether or not there are actually consequences to not following the rules in New Mexico, I wanted to show you a couple of cases that illustrate that it can be a very serious problem for you as lawyers. If you think about our justice system, our judiciary in New Mexico, all of our trial judges are handling a minimum of 1,000 cases a year. Some of them have over 2,000 cases a year. So the time that they really have to devote to following up on your research is very limited. With that size of caseload, we need to be more efficient, and that's why we've designed some of these rules to make it easier for the judge to actually access the record and the case law. If you look at the first case in New Mexico, it's the Martinez versus State Taxation and Revenue Department. It's 1999 NMCA 103. If we can put that up here, that's how you would access it online or even on disk. And if you come to this opinion, right out of the gate, in paragraph number 1, what the court is saying, you can go to the paragraph, you see the paragraphs, numbers there. On our own motion, this court ordered the MVD attorney to show cause why she should not be held in contempt for violating the rules of appellate procedure. On October 20, 1998, we had admonished her in a published opinion for failing to comply with the rule requiring that factual assertions in a brief be supported by citations to the record. The brief in chief in this case, filed less than 5 months after the admonition, violated the same rule. The appellate briefs submitted in these cases failed to satisfy even minimal appellate standards. Therefore, we take the extraordinary action of dismissing the appeal. That's in paragraph 6. So even in that case, the Court of Appeals dismissed the case simply because the lawyer was unwilling to abide by the rules in New Mexico. The second case is Washakie versus Bernalillo County. That's 2010, NMCA 021. And Brad, when you access that opinion, can you show us how to get straight to paragraph 15? The lawyer should have cited the case, the paragraph symbol with paragraph numbered 15 and 16, and you're able to go right to it. And they say, we do not address BCSD's challenge of the district court's findings of fact substantively because, in its brief, BCSD does not conform to the New Mexico rules of appellate procedure. Its brief renders it virtually impossible for us to review its assertions because it fails to cite the record and fails to present the evidence as a whole. The only way to properly support a challenge to the sufficiency of the evidence is to include in the argument section of the brief in chief citations to authorities, record proper, transcript of proceedings, or exhibits relied upon. And here's old case law that they're relying on. Where a party fails to cite any portion of the record to support its factual allegations, the court need not consider its argument on appeal. And lastly, the argument section of BCSD's brief includes no citations as required by the rule. Its multiple assertions are virtually impossible to confirm given the large record, a 1,300-page record proper, multiple volumes of trial testimony, transcripts, and exhibits. This court will not search the record to find evidence to support an appellant's claim. So the consequences of not following the citation rule in New Mexico is important. But that happens to deal with the record proper, right? And that one seems to be a lot easier than citing to case law. But Rule 23-112 gives us these citation requirements in all of our courts. So in every court in the state, when you are citing a case law, it's your responsibility to cite to the case by the neutral citation. You don't have to cite to the New Mexico appellate reports, but you also have to give us the paragraph number where the proposition is located. And just to illustrate the difference between New Mexico's system for compiling its opinions and other states, let's go to the Kentucky versus Public Service case. This is an Indiana appeal case, 393 Northeast 2nd, 776. So if you go to Google Scholar, you can access case law online on the New Mexico OneSource by going to Google Scholar. You can type in the citation by simply inserting it in that box. And doing the search. And if you wanted to pull up, here the citation would be to pages 783 and 784. So that's what you're having to do. You're having to scroll through this without having to use Control F to put in your paragraph number. And so you can see the amount of time that it takes just to access that information. But once you get there, you then have to find the proposition that is cited. And you notice a number of different paragraphs on page 783, so you have no idea. That just illustrates in my mind how efficient the New Mexico system is compared to how other courts are publishing their work. But in that case, the proposition I wanted to cite it for is that the procedural rules are for the benefit of the courts. that court went on to explain that although it might disadvantage your opposing counsel in rebutting or explaining the assertions advanced against their client, if you fail to comply with these rules, the court was unwilling in that state, in that case, to dismiss the complaint. That was a remedy that was sought. And just for humor, I thought we should access another case, a federal supplement case. Federal district court judges seem to be a lot more colorful than some of our state district court judges with what they write. So I thought this would be a fun case to illustrate. It's 147 F sub 2nd, 668. You also notice below it, you could go straight to federal courts and access their databases. You could go to any of the other states and access their databases as well. Or you can just simply use the Google Scholar. Bradshaw versus Unity Marine Corporation. And toward the beginning of that opinion, there's no paragraph number, so it's hard to give you that information. If you scroll down, before proceeding, here's how the court decides to introduce the argument. Before proceeding further, the court notes that this case involves two extremely likable lawyers who have together delivered some of the most amateurish bleedings ever to cross the hallowed causeway into Galveston, an effort which leads the court to surmise with one plausible explanation. Both attorneys have obviously entered into a secret pact, complete with hats, handshakes, and cryptic words to draft their pleadings entirely in crayon on the backsides of gravy-stained paper placemats in the hope that the court would be so charmed by their childlike efforts that their utter dearth of legal authorities in their briefing would go unnoticed. Whatever actually occurred, the court is now faced with the daunting task of deciphering their submissions. With big chief tablet readied, thick black pencil in hand, and a devil-may-care laugh in the face of death, life on the razor's edge, sense of exhilaration, the court begins. So 3 paragraphs down, they explain one of several things that the lawyers did wrong. But what they said is that the plaintiff cites to a single case from the Fourth Circuit. Plaintiff citation, however, points to non-existent volume 1886 of the Federal Reporter, 3rd edition, and neglects to provide a pinpoint citation for what, after being located, turned out to be a 40-page decision. Ultimately, to the court's dismay, after reviewing the opinion, it stands simply for the bombshell proposition that torts committed on navigable waters require the application of general maritime rather than state tort law. The court cannot even begin to comprehend why this case was selected for reference. So it'd be like citing to a case on motions for summary judgment. So the court was dismayed. I thought it was a colorful way to sort of end my presentation. I don't recommend that for our appellate judges or any judges. I still believe in civility, in what we write and modeling civility. But the bottom line for you is that if you use New Mexico OneSource and you have the online service, you have access to up-to-date information from the Supreme Court opinions. You will have updated information regarding any amendments to the rules, and you will always be in a position to be able to accurately represent to the court what the state of the law is in the state of New Mexico. We believe in this product as the Supreme Court. We encourage your use of this product, and we think that it will make our system more efficient and more effective. Thank you.